We are going to bring in defense attorney and legal analyst Patrick Caffery now. Thank you so much for being here this afternoon. Let's jump right into this. We saw Kyle Rittenhouse take the stand this morning. What is your immediate reaction to what you've seen so far, and what are your main takeaways?
So good afternoon. What I'll start with is some of the fireworks that people have been commenting on are not things that the jury saw. So you saw the judge sort of give a tongue lashing to the prosecutor, and that makes for dramatic television. But the jury was outside of the room at the time that happened. So that's not something that they're going to take into consideration. As far as what the jury actually witnessed and what they're going to consider, I believe that Rittenhouse did make his case for self-defense. That is clear, that he said that in his mind he had no choice but to do what he did. Whether the jury ultimately believes him on that is a different story. What the state has to do, in my estimation, is they have to focus on the issue of provocation. If they fail to demonstrate that Kyle Rittenhouse provoked these attacks on him and therefore lost the right to use deadly force to defend himself, then I believe the state has lost the case. As far as the cross-examination by the state thus far, I haven't seen any focus by the state on the issue of provocation. The cross-examination isn't over as far as I know, but thus far they really haven't focused on that issue, and I think it's probably the most significant issue of the trial. So we'll see where the rest of the cross-examination goes.
And you mentioned the fact that some of the most memorable parts for us that we've seen so far today, the jury has not been in the room for. We saw Kyle Rittenhouse get very emotional at one point, to the point that the court did take a break. Do you think that Judge Trader made a good decision calling for that break in that moment, and why might some argue that break was so necessary?
So the court at the time said that he intended to take a break regardless of what Rittenhouse's emotional state was, which is typical for judges to do sort of mid-morning, which would have been the same time that this was happening. I don't think the judge timed this in a way that was designed to assist Rittenhouse. These kinds of things happen occasionally during jury trials where witnesses become overcome with emotion and they're really not able to perform, for lack of a better way of saying it. They're not able to answer questions. And it doesn't make sense to have the jury just sit and watch somebody cry. So the judge rightfully, I think, took a break. I don't think that necessarily helps Rittenhouse or hurts Rittenhouse. It was just what the judge thought should be done at the time.
And then later on, during cross-examination, we did see the jury sent out of the courtroom for a moment twice now. What is the judge so upset about in those moments? What's wrong?
So the prosecutor started to ask questions that nibbled around the edges of the fact that Rittenhouse invoked his Fifth Amendment privilege. He did not make a post-arrest statement that was ultimately going to be used by the state in this case. And it's the third rail in criminal cases for prosecutors to start talking about the fact that a defendant has not previously told his or her story. So the prosecutor didn't go into that directly, but the defense attorney rightfully recognized that that's really what the insinuation was. The prosecutor was trying to point out to the jury, hey, this is the first time Rittenhouse has really told this version of the story or told this complete story. And the prosecutor's intent was to undermine Rittenhouse's credibility by doing that. The judge rightfully stopped the prosecutor from doing that. There's very clear case law that's existed for decades and decades that prohibits the state from going into that information. Now, with that said, you'd have to be a really savvy juror to recognize that that was what the issue was, and that's why the judge was upset. They were sent out of the courtroom. The judge addressed it in a dramatic way, but the jury is not aware of what it is the judge was saying there. So then the second issue related to pretrial rulings where the judge had prohibited the prosecutor from going into what we call other acts evidence. There was information that suggested that Rittenhouse had wished that he had a firearm with him while he was witnessing a property crime and said that he would have shot the people who were committing the crime if he had his gun. The judge previously said, I'm disinclined to allow the state to go into this, but left the door open for the possibility that he would allow the state to go into that issue. The state started to go into it, without the court's permission. And the court got so upset because basically they were saying, hey, I told you it was highly unlikely I was going to let you to go into this. If you thought that the door had been opened, you needed to take a break outside the presence of the jury and ask me for permission to go into this issue, which you did not do. And then he shut the state down from going into that issue again. So again, it makes for interesting television. There's some drama there, some fireworks from the judge, but the jury didn't witness that. So the impact that that will ultimately have on the jury is questionable because, again, you'd have to be a very savvy juror to recognize that that was an issue.
Very important insight there, especially as we now see more conversation on social media about that warning of a mistrial. In your expert opinion, is that a big risk right now?
I think that the judge is upset enough where he would entertain a mistrial. And again, if you listen to the words that the defense used, they said mistrial and dismissal with prejudice. And the difference is between prejudice and no prejudice is a mistrial can be declared and then a case can be tried again if the case hasn't been dismissed with prejudice. What the defense is saying is if they do something like this again, we're going to ask judge that you declare a mistrial and then dismiss the case in a way that it can never be brought back again, which obviously the state doesn't want to happen. The judge hasn't indicated that he will definitely be willing to do that, but it appears that he was so upset and so concerned about the state's behaviors that he may take that into account and grant a defense motion if the state crosses the line again.
And as far as, the jury being back in the courtroom, what are you now listening for? What would make your ears perk up at this point?
I'm sorry if I sound like a dead horse on this provocation issue, but I really do think that that's what this case comes down to. So what would make me perk up as an observer of what's happening in the courtroom is if the state started to ask questions that were designed to get Kyle Rittenhouse to recognize or acknowledge that he did things that would provoke people to attack him. The state has really failed to focus on his behavior, his presence with the firearm, and how that would affect the average person seeing him with that. Other behaviors that he engaged in that would draw attention to himself and ultimately cause people to attack him. The most obvious thing that he did that would cause people to attack him is he shot and killed the first person. Had he not done that, then no one would have had the right to try to disarm him. But once he shot and killed that person, it is most certainly reasonable to believe that other people would then try to disarm him. And he shot and killed other people during the course of them attempting to disarm him. So I really think that's what the state needs to focus on to be able to make its case. The rest of what happened really isn't in dispute. So to focus on things that aren't in dispute is really ineffective. It doesn't get to the primary issue that the jury is ultimately going to have to decide.
Local defense attorney and legal analyst Patrick Caffery following along with us as Kyle Rittenhouse takes the stand. Patrick, thank you for being here this afternoon.
Thank you.
A reminder,